morning, Ms.
Good morning.
Ibson. God, the second person I'm having trouble with. Anyway, we appreciate you coming this morning. I see you brought a guest. Why don't you introduce him, and then afterwards you can begin your opening remarks.
Thank you, Your Honor. I brought with me today my husband, Wendell Eck.
Nice to see you, Mr. Eck.
Good morning. Over the course of my 30-year career, I've litigated cases in the trial courts of Illinois, Iowa, Kansas, Minnesota, Mississippi, Missouri, Nebraska, New York, and Oregon. I briefed and argued appeals to the U.S. Courts of Appeals for the 8th and 9th Circuits, to the state Supreme Courts in Iowa and Nebraska, and to the state Courts of Appeals in Iowa, Minnesota, and Nebraska. Here in Iowa alone, I've represented clients in proceedings before the Civil Rights Commission, the Department of Education, the Department of Human Services, Inspections and Appeals, the Insurance Division, Workforce Development, the Workers' Compensation Commission, and the state boards of chiropractic, medicine, nursing, pharmacy, podiatry, psychology, and the Real Estate Commission. I've represented clients in small claims court, family court, juvenile court, probate court, criminal court, and district court civil docket. Some of those cases resulted in appeals to the Iowa Court of Appeals and/or the Iowa Supreme Court, which I also handled. While I have not served as a judge, I have tried many, many cases to administrative agencies and district court judges, at the conclusion of which I wrote and submitted proposed findings of fact and conclusions of law. My clients have prevailed in virtually every one of those cases, and each time my client prevailed, the court's written decision incorporated much or all of what I had written and submitted post-trial. There is virtually no area of substantive law in which I do not have at least some degree of experience. The law is as much a part of my DNA as are my own children. I'm a worker. When I'm not working on my own cases, I'm reading opinions and briefs in other people's cases. I also run my own business. I work alone, without support staff. I do everything from the bookkeeping to the brief writing. Since I was last here 2 months ago, I have tried a case to judgment in favor of my client, resolved a breach of contract suit after more than 4 years of litigation, intervened as coverage counsel in a complex workers' compensation case, resolved several family law matters, and settled my family's case against United Healthcare after some 6.5 years of litigation, including 2 appeals to the 8th Circuit. I've also filed 3 new lawsuits, taken on several new family law, real estate, and coverage clients, been retained as an expert witness in a complex case, and am preparing 2 cases for trial, plus 1 for oral argument to the Nebraska Court of Appeals, all taking place within the next 2.5 weeks. I was also elected to a second term as president of the 5,000-member Beaverdale Neighborhood Association, and work closely with elected officials and the media, advocating in favor of the local option sales tax, which was approved by city voters earlier this month here in Des Moines. There are a number of areas in which I believe I would be of particularly valuable service to the Court of Appeals and the people the court serves, including appeals from judicial review of agency action, for example, Medicaid and other benefits claims, workers' compensation and employment cases and the like, cases involving evidentiary rulings by the district court, both civil and criminal, and cases involving challenges to jury instructions, whether given or not, by the district court at trial. On those occasions when I've been retained to take over a case on appeal, the first thing I look at are the applicable rules, standards, statutes, and, where applicable, common law. Were they properly construed, interpreted, applied, and followed during the trial phase of the case, including discovery and everything leading up to the trial? The second thing I look at is, did trial counsel do everything he or she could or should have? Because that is the bare minimum of what we owe our clients. If the answer to either or both of those questions is no, then one or maybe both of those parties didn't get what the system promises, which is a fair opportunity to present their evidence to a neutral fact finder assisted by an effective, zealous advocate. With very limited exceptions, every litigant in Iowa has the right to appeal. The vast majority of those cases are heard for the first time, and most often the last time, by the Court of Appeals. The court's workload requires judges with a keen intellect and incredible work ethic. In the last term alone, the Court of Appeals issued opinions in 65 cases. Of those 65, 3 appeals were dismissed. The court reversed and remanded in only 5 cases. That the court affirmed in 57 of the 65 cases tells us 2 things, I think. Number 1, our trial court system works, and it works well. Number 2, those litigants got what the system promises: a fair consideration of the facts presented and the law as applied to those facts. When I was here last, I spent a great deal of time telling you my life stories, both personal and professional. Today, I'm going to share just one short tale in conclusion from July 15th, 2009, nearly 10 years ago. I had been at hospice that evening when my husband, Jay Wagner, died. It had been a long and sometimes difficult journey, and I still had one thing left to do, and that was to go home and tell our children we had reached the end. As much as I believed that I had done everything within my power to prepare all of us for what I knew was coming, nothing really prepares you for telling your children their father is gone. I got home and my own father was sitting in a chair in my front room. He was 85, and as it turned out, nearing the end of his journey. I sat at his feet and I looked up at him and I said, "How on earth am I going to do this?" And he gave me a little smile and said very simply, "You're going to put one foot in front of the other and get her done. It's what you've done your entire life." It is difficult for me to sit here and sell myself. Shameless self-promotion. It feels very awkward to me. But I think what my dad said about me is what I bring to this room at this moment and what I will bring to the Court of Appeals. The ability to put one foot in front of the other and just get her done. Thank you.
Thank you very much, Ms. Ibson. We'll start questioning with Ms. Pearson.
No questions.
Ms. Bowden?
No questions, thank you.
Mr. Berger?
No questions.
Mr. Diaz?
So you just described that incredibly busy schedule that you have, I think, in the next couple of weeks. Is that normal? And how do you do it? How do you balance all of these things that you've told us about?
It is normal. Sometimes they're busier than others, of course, and that's the nature of a private practice. I balance it by first, I'm a creature of routine. I start every day the same with 2 cups of coffee and 2 hours at the gym, getting my head straight, and I do a lot of my best thinking on the treadmill. I think it's all about...
While drinking coffee?
No, I do the coffee first, then the treadmill, and then more coffee, obviously, as you can tell by my demeanor. It is all a matter of balancing your time, and for me, too, it's not just a matter of balancing my professional commitments, but making sure that I am allowing adequate time for service to my community, and then, of course, for the past 18, 20 years, raising children. I think somebody asked me a very similar question last time, and I said, I just don't require a lot of sleep. And it's a gift, really. I somehow managed to get a lot done in fairly short order.
Thank you.
Ms. Law?
Yes, you mentioned that currently you work without any staff or any support. How would you make the adjustment to having staff to be able to help you if you're on the Court of Appeals?
Well, I always had staff, of course, when I was in larger law firms, and did initially when I went off on my own. The main reason I don't use secretarial staff is because I type very fast. I played piano since I was 4 years old, and if any of you are piano players, you know the keyboard and sheet music is very much the same as, typing a brief or making corrections, and I found I just was more efficient. I will welcome having people around me, and I think I talked about this last time also. I loved going off on my own, and it was the right thing to do at the time for my family and for my clients. But it can be very isolating. And so I'm looking forward to being able to work with other people. And I mean with when it comes to support staff. And that was something I took very seriously at my former law firm, was that we need these people a lot more than they need us. And I really trying to change the culture of that firm in terms of how we treat support staff, because I think that really is true.
Thank you.
Mr. Bevel?
No questions.
Mr. Sukup?
Thank you. Sorry we didn't get our personal meeting this time, but enjoyed the last one. I'm going to take a wild stab at Horbach's one-word description. It's either zealous or advocate, but anyway, we'll see. Spitfire. Okay, somewhere in between. So there's no doubt that you have a real gift with your clients, and you can see the passion in it. So thank you.
Thank you. I appreciate that very much.
Ms. Sinclair?
I see by your application that you would like to finish up your career being a judge, and you have opted not to apply to the district court. Could you explain why?
There are a couple of reasons behind that. First of all, and I think I talked about this last time also, to go through this process requires a lot of self-examination. I mean, you have to sit down and say, okay, what am I good at? Where are my particular skills? In my case, I think the way my brain works is best suited to appellate work, the research, the writing, the analysis. For example, a case comes before the Court of Appeals, you're going to get a brief with a whole lot of stuff in it that has nothing to do with what the real issues are on appeal. That is something, back when I was in law school, we called it book briefing. Some of you might remember doing that, where you had a law book and you highlighted, and that's how we learned how to analyze cases. That's really the way my brain works. Trial court work is very, very different than that. I've loved being a trial lawyer. I'm not sure that that's the best place for me. I think appellate work at this point in my career is where I belong.
Ms. Diekman?
Thank you. Following up on Mr. Sukup, regardless of whether you're a zealous advocate or a spitfire, you've always been known for your advocacy. As a Court of Appeals judge, of course, advocacy is not the issue, and so I would like you to address that, how you switch gears from writing the briefs in the form of an advocate to writing opinions.
Right. So I am a zealous advocate for my client, but even as I've tried cases, it's been very important to me to sit the parties down and say, what are the real issues in dispute? What are the things that we can agree on? Let's cut out the extraneous matter and get really to the heart of the case. Certainly on first view, as an appellate court judge, I'm going to have two briefs, two very diametrically opposed viewpoints as to what happened at trial. And I'm going to have to be able to sort through all that with, in certain cases, of course, the advantage of also having oral argument on behalf of the parties. I am a very thoughtful person. I always see three sides to every story, and that really is the nature of trial work. There's my client's side, there's their side, and then there's the truth, which is generally somewhere in the middle. And I've always been that way, and I've really tried to conduct myself that way out in the community and in my practice. And so I think that's where, the thoughtful kind of approach and saying, look, sometimes there are two sides to a story. On evidentiary rulings even, there can be two sides to a story. But somebody's got to make a decision. The Court of Appeals, of course, their review is confined by, did the district court do things the right way? We're not going to take new evidence. We're not going to make separate inquiry. We're not going to do our own investigation into the facts. We are just going to simply look at what happened at trial. Were the procedures properly filed? Was the law properly applied? And so those are the kinds of decisions we're going to have to make, and I'm very comfortable doing it. I mean, I've basically been doing it my entire career.
Thank you.
Mr. Goodman?
Ms. Ibson, thank you very much for your application. I've enjoyed all of our visits and your public presentations as well. I've asked this of a number of applicants, but I'd be interested in your opinion. We have 30 applicants, 12 judges, 18 private and public practitioners. Some believe that we should just pick from the judges and appoint those to the Court of Appeals because they have the experience on the district court bench and would be the best judges of the judges that sit in judgment at the trial level. That's hard for me to do, but it would be easy because there are 12 judges to fill 6 slots. We have great private practice lawyers. You're included in that group. You've had some tremendous life experiences on the other side of the legal system, litigating your past husband's legal proceedings. And we have some excellent government practitioners. What I'd like to know from you is, what do you believe we should consider in deciding who to put in these 6 positions? And what kind of experience should we select from?
Well, I'm not gonna say whether you folks should pick a practitioner or a judge. Only you can make that decision. I will say this, here's what I bring that I think other people don't. And that is that broad base of experience in virtually every subject matter that comes before the Court of Appeals. I think I said last time and in some of my individual interviews, in my view, I don't think anybody should apply for a position on the bench, particularly as an appellate court judge or justice, unless you've got a really good, solid foundation of experience as a practitioner. You cannot sit up there if you don't know what it's like out here. That's my view. And as you mentioned, I do bring the unique perspective of not only having been a trial lawyer for 30 years, but having been a litigant for the last 6.5 of those years. So I'm sure district court judges bring a special skill set to the appellate bench. I don't know what that skill set is because I'm not one. I only know what I can bring to the position.
All right, thank you very much.
Mr. Bloom?
No questions, thank you.
Ms. Conover?
No questions.
Ms. Roberts? Ms. O'Brien?
Ms. Ibson, you have certainly practiced in a lot of different states and jurisdictions. How does that leave you feeling about the Iowa system? And how do you think that would affect what you bring to the Court of Appeals, your experience in all these other states?
Well, there are a couple differences that stick out to me. One is between the way we practice law in Nebraska and the way we do things here. For a long time in Nebraska, litigation was driven by the lawyers. If you wanted a scheduling order, you had to ask for one. Now that has changed. What I like about the Iowa system is the judges control their courtrooms, and that's what needs to happen. From an appellate standpoint, I haven't really experienced a lot of differences. One big difference between Minnesota and Iowa that the folks on the Supreme Court might think about at some point when we look at budgeting issues is in Minnesota, every time you file something, there's a filing fee. So any motion has a filing fee attached to it, whether it's in district court or the appellate courts. And I have to assume that's how they keep their budget nice and healthy. I think, again, we do an exceptionally good job here. I will tell you the lawyers that I practice with in other states, and again, I don't want to disparage anyone, but there is a level of professionalism, of collegiality, of relationships between the bench and the bar in Iowa that I think is very unique and something we should be really, really proud of.
Mr. Horbach?
No questions.
Mr. Gray?
I have no additional questions.
Does anybody have any other questions? We have a few minutes. I don't have any questions. We really appreciate you coming this morning, and we wish you the best of luck.
Thank you very much, Your Honor. Thank you all.
Thank you.